Dean asked me to lead off, so I appreciate the invitation for being back here. I've been to Penn Law quite a few times over the years, and actually I teach, one of the things I teach at Yale Law School is a sort of basic political science-y course about the Supreme Court, and I assign some of his articles on the role of the Chief Justice, and those are, they have not gone out of style. So we're going to be really conversational and try to leave a lot of time for your feedback and your questions. And the question we're asked to address, is the Supreme Court different? I think based on what everybody has said, including the lunch panel and various comments during the day, we can stipulate that the answer is yes. So I will redefine our assignment as to say, in what ways is it different? Are any of those ways problematic? And given the huge role the court plays in American life, is there anything it should be doing that it's not doing, or is there anything that it should not be doing that it is doing? So with that in mind, I'm going to just look back on a few months ago. So back in the winter, our president announced a state of emergency at the border with Mexico that he said entitled him to take money that Congress had not appropriated, had appropriated for other purposes, billions of dollars of such money, and diverted to building the wall on the border. And when the president announced this, he had this to say: "We will then be sued, and we will possibly get a bad ruling. And then we will get another bad ruling. And then we will end up in the Supreme Court, and hopefully we will get a fair shake and win in the Supreme Court, just like," and he went on to describe the Muslim travel ban case. So what did the court do about that? So the lower courts enjoined this highly unusual diversion of unappropriated money. And the case came up to the court in the middle of the summer. So the court was not in session. And the court summarily, without granting the case or giving it plenary review, lifted the injunction with a one-paragraph decision explaining that, in the majority's view, the plaintiffs in this case, that was the Sierra Club raising environmental concerns about the wall. The Sierra Club didn't have standing. It was not within the APA zone of interest. And that was that. So I think, based on Charlie Jay's presentation and other things that we heard today, what the court owed the public, given the very freighted atmosphere we're in, the collapse of the kind of norms on the environment that Dean Levy talked about this morning, what the court owed us, if indeed there were a majority of justices who thought that these plaintiffs didn't have standing, I'll assume, arguendo, that that's what they actually thought. Explain it. Explain it to the people. Give us one more paragraph, because the president has served up to the court an enormous and dangerous challenge. I'm counting on you to pull my cookies out of this fire, which I have just lit. And it seems to me the court is in a very perilous time. And because the court is different, and because we all pay attention to the court, most Americans don't pay much attention to the court, but they do pay attention when something comes across their screen. The court owes us at the least a reasoned explanation of what it's doing, so that it doesn't leave us to assume, well, yeah, you know, maybe they thought the plaintiffs didn't have standing, or maybe they just wanted to save President Trump the trouble of having to undergo plenary review. The court's shadow docket, which is the current jargon for the activities that the court undertakes in the absence of plenary review, is something that has lent itself to, has become very useful to this administration. The Solicitor General is very active in going up to the court with emergency applications to lift stays or enter stays or whatever. And the beginning administration, that wasn't succeeding too much, but in the last term, it's been highly effective. And so I'll end this little peroration by saying, regardless of whether any of us in this room think the court is doing the right thing or the wrong thing, I think the court ought to have a felt need to speak to us and explain itself, explain what it's doing.
Thank you, Linda, and it's a pleasure to be here with you. I think I'll start with kind of a meta point, which is certainly not the scope of our panel, but we've talked a lot today about kind of fragmentation in our view and the public's fragmentation in the view of the court and judicial independence, and in our politics generally. And among the variables that go into that is kind of fragmentation in our media. And, you know, to be blunt, it's, and I think about my own legal learning, there is no Linda Greenhouse today. There is no go-to source for the Supreme Court, for the public or the profession, in the same way that the role that Linda served so exceptionally notably. And I think that is part of this discussion today and what we infer as public attitudes to the judiciary. Of course, it's a much bigger piece of that. But I do want to, I guess I'll offer both a somewhat more optimistic view about the court's legitimacy and then perhaps a few cautionary notes about perhaps ways in which the lower courts, even in Article 3, not state courts necessarily, but the lower federal courts may be at risk of behaving in some ways like we say the Supreme Court is, along lines of appointing president, in ways that might give us some pause. But the good news is the Supreme Court is still, well, I hear a lot as dean about grade inflation, and what we have we have the reverse phenomenon in our public life in terms of trust in institutions. We have kind of confidence deflation in all major institutions for the most part over the past decade or two. And in light of, especially along that deflating curve, the Supreme Court in Gallup polls done every year for the last 40 years is holding up quite well. 78% of Americans in this year's poll have at least some confidence in the Supreme Court. That compares with only about 30% in Congress. The court confidence, public confidence in the court outrates churches and organized religion, universities, big labor, big business, pretty much every institution in society other than the military. And it's far ahead, sorry Linda, of newspapers, but newspapers are even ahead of internet news. So, but you know, so this is a fact that, and it's pretty stable. It's not as different from, indeed, the court's public confidence was lower 5 or 10 years ago than it is in the past 2 years. I'm not going to go into why that may be, and I'm not the right person to do that. But the court has maintained a level of public support, even where other governmental institutions have been sinking, and other institutions generally. And I think that says something about the good job that the justices do, the judges in the overall judicial system do, and in kind of projecting, although in ways that empirics show the voting may be correlating more with political lines. Something that other panels have addressed, the mode of rhetoric, the reason giving, the kind of explaining decisions in a dispassionate, well-reasoned way, which I think the norm of kind of reason giving and writing opinions is as important as anything to judicial independence. Imagine moving to a regime next year where we had everything was the same in terms of how we appointed and tenured judges, but they didn't have to write written opinions or promulgate them. We would lose something deeply, both in terms of the public interaction and also the way in which judges and anybody who has to make a decision is bound as against both the past, but also the future, by giving good reasons for it, because judges know that another case with perhaps a different personal or political valence might come up, but implicate the same principle, and people want to be seen as consistent. So that's really important. And so we do have those structural things in place. Now, I think indeed, some of these public opinion polls I referred to list high public approval for the court, but also about 50% of Americans think the court is, quote, a little too political some of the time, or something like that, a kind of a fuzzy, I don't know if that's proper survey language, but I may not be quoting it right. But the point is, and I guess I would put myself in that camp, as many of the prior speakers today have, that the notion that judges would bring personal philosophy, preference, worldview, and here vocabulary matters, but at least put in those kind of normatively favorable terms to the act, the very difficult act of making decisions, particularly at a Supreme Court, which here's the hardest cases, I think is not only perfectly fine, it's probably desirable, and indeed I would argue the framers intended it. And I guess I want to talk just a bit, and then we want to open it to questions about we've talked a bit about state elected judges. I would argue that our constitutional design did not go to the other pole. As Kathleen Sullivan mentioned at lunch, we could imagine a system where lawyers and judges, we kind of appointed our own. The framers baked politics right into the judicial appointment process. So I think it ought not be surprising that presidents who themselves have different worldviews would seek to ascertain predictable worldviews in the people they appoint for life, okay? And that's been true from the beginning. I would point you to an election where the incoming president sought to delay and oust some nominees and appointees of the prior president. I'm talking about the election of 1800, Marbury versus Madison, and so this is quite baked into our system. So I guess I'm less, and we've gone along pretty well. I'll note two notes of concern, and then kind of I think we both want to open it up to discussion. The first is that, and this goes to something Paul Clement said at lunch that picked up on something Dean Levy said earlier about the judges wearing the different colored robes. A remarkable study from actually a Duke law professor, Neil Siegel, along with Neil Devins, tracked hundreds of cases going back to 1790. So picture the judges in robes by party of appointing president. This is actually thousands of cases that were deemed as important, closely divided cases with at least 2 dissenting votes. I guess hundreds is the baseline. From 1790 to 2010, there were only 2 of those divisions where the justices split on party of appointing president lines. Only 2 out of hundreds. So yes, we had close cases, we had judicial philosophy sneaking into these intractable disputes, but only twice in well over a century, well, basically 2 centuries, did we get stark party lines. Now, from
what was the time frame of that?
1790 to 2010.
2010.
Now, applying the same decisional rule, there were 8 cases deemed important, probably by New York Times placement, which is the industry standard for deeming salience. From 2010 to 2014, so just 5 terms, there were 8 of those cases. There were 8 cases where the justices split exactly on party of appointing president lines. And so it would be no surprise that observers of the court, whether with fancy law degrees or members of the public, would perceive the court as more partisan, because it's certainly, whatever the judicial mindset of the justices, they are appearing to vote more in partisan lines. Now, I would say, to take the focus off judges, that could actually reflect a change in presidential behavior, in the vetting and selecting of judges who are more predictable and more partisanly aligned. It also could reflect, of course, the Senate behavior in its behavior. And there's a couple other statistics. We'll do audience participation. You can yell out, I know the answer, I know what I'm going to get here, but yell out the names if you know of a senator who voted against Justice Scalia's confirmation to the court. We should have nobody yelling because there was not a single opposing vote. Justice Ginsburg only had 3 opposing votes. You get to Kagan and Gorsuch, and they both had about 40 votes against them. So these are, there's been a change in the partisanship in the Senate. I think there's been a change in the presidents of both parties in really kind of vetting nominees for ideological certainty, perhaps, and I think that's something we should be concerned at, both at the Supreme Court and in the lower courts. There's more I could say, but we'd both rather hear from you or Linda.
Yeah, so I have a couple of things to say about that. So one, on your great inflation, on the public approval of the Supreme Court, when you penetrate that big number, the partisan divide is scary and getting bigger. So not that poll, but a Pew poll this summer showed that 75% of self-identified Republicans thought the court was doing a good job, and of self-identified Democrats, it was, I think, less than half. And that's a really key number, I think. And as I think, maybe it was Charlie Jay who said, public rule of the court has become very unstable, and it seems to reflect, what the last term's big cases were. It's not stable, and it's not uniform across ideologies. The second thing I'll say is that Neil Siegel and Neil Devon's study, I think, is very sketchy because, of course, what we have now is the first time in, I'll say, modern American history. I'm not a historian, so I can't say ever, when the ideology of the members of the court maps completely onto the partisan identification of the president who appointed them. That hasn't happened before. So, look back to, let's say, the Guantanamo cases after 9/11, when the court surprised a lot of people by pushing back against the Bush administration's effort to create a black hole at Guantanamo Bay, a series of cases starting with Rasul, ending with, 4 years later, with Boumediene. Those were just a fascinating set of cases. You could think those cases were great, or you could think those cases were terrible. But what you couldn't think was that the Supreme Court was carrying water for the president one way, or was seeking to, diss the president in the other way. Why? Because the partisan identification, the ideological identification of justices didn't map onto that. And that's crucial, I think, for preserving the court's legitimacy. And you can go back to any number of cases. So that data set included, Earl Warren appointed by Dwight Eisenhower, William Brennan appointed by Dwight Eisenhower. It doesn't mean anything. I mean, I hate to...
Well, but again, do you think, Linda, might it mean something about Dwight Eisenhower and the folks he was using to pick judges compared to President Trump or Obama?
Those questions are super interesting. But that's deeper. That's not what they were purporting to show. Certainly the political atmosphere surrounding Supreme Court confirmations has just become so toxic. It's like where to begin, and maybe we don't even want to begin there. So maybe we should pivot a bit and talk about stare decisis, because that came up in the last conversation in a very interesting way. So, for instance, how do we interpret a Supreme Court decision that purports to be adhering to its own precedent, but actually isn't when looked at objectively? I think that's, I like to put people on notice about this. So the Congressional Research Service, as many of you probably know, puts out what's called the Annotated Constitution of the United States. It's a huge document, which you need to be in pretty good shape to pick it up, but fortunately it's online. And one thing they very interestingly do is they keep a list of Supreme Court decisions that have overturned other Supreme Court decisions. And they don't just go by what the court says it's doing. They have nonpartisan experts at the CRS who do it based on, their reading. And I give this as a little trick to my students. I have them, look at that list. And so, for instance, Gonzalez against Carhart, which was the partial birth abortion case that came down in 2007, purported to adhere to the precedent of Stenberg against Carhart, which had been the 2000 case before Justice Sandra Day O'Connor retired and was replaced by Justice Sam Alito. The court in the second of those two cases said it was adhering to precedent, but that there were factual differences and so on and so on. CRS says no. CRS lists Gonzalez against Carhart as the case that overturned Stenberg against Carhart. Today we have a case pending that was granted earlier this month, a case called June Medical, which serves up to the court the meaning of Whole Woman's Health against Hellerstedt, which was the 2016 opinion that overturned the Texas anti-abortion law that imposed admitting privileges on doctors who perform abortions, and the Supreme Court in Whole Woman's Health said that's an imposition of an undue burden on access to abortion because you weigh the benefits and the burdens, and there's no medical benefit, and the burden is very severe, and that will cause clinics to close because doctors who perform abortions are denied admitting privileges at hospitals in many of the red states. Fifth Circuit looked at that case. That was a Fifth Circuit case. Court overturned the Fifth Circuit. The Fifth Circuit had an identical case from Louisiana, and they said, well, yeah, we know that we were overturned in Whole Woman's Health in the Texas case, but this is Louisiana, so we're going to uphold it. That's now up at the court, and we're going to see whether the Supreme Court is going to say, Whole Woman's Health is on the books, excuse me, this is an undue burden case over. Or they're going to say, well, the travel distances are less in Louisiana, and the this thing and the that thing, and make a factual distinction and purport to be upholding Whole Woman's Health while sending a big signal to the world that all you have to do is say it's 10 miles less to travel away from the closed abortion clinic to the one remaining in the state, and get by. So stare decisis is not a black and white issue. It really, you've got to study it on the ground, and I think part of journalism's obligation in informing people about the court is to do the heavy lifting and read the cases, and don't take anybody's word for it, and be able to show the public, here's what game is really afoot. And my fear, just speaking as a citizen, is that if the court does what I think some of the members of the court would like to do and uphold this Louisiana law, the takeaway is going to be, well, at least they didn't overturn Roe against Wade. And, we'll see.
I think I wanted to extend the discussion of stare decisis to talk about the distinctive nature of the Supreme Court relative to the lower courts. And as many speakers have, I think, our discussion today, as in many of these conferences about kind of law and politics or impartiality in the judiciary, we're arrayed along a spectrum in kind of degree rather than kind, in that I think every speaker I've heard agrees, as we do, that law matters. Every speaker, although we use different vocabulary, has said something about judicial philosophy or sometimes preference, or the scholars say attitudinalism, or maybe politics, although I think that's often not a straight line there. So often the question is kind of, what weights do we give to those different judicial variables? And I think I agree with all of the speakers who've said that because the selection bias of the Supreme Court, the difficulty of the cases, the stature and maybe public nature of the justices, there may be more discretion, or there is more discretion at the Supreme Court than in the lower courts. I do want to speak a bit about an interesting study that suggests that discretion creeps in certain ways and at certain times with the federal circuit courts, who are, of course, appointed under the Article and serve under the Article 3 structure, but nonetheless are influenced in some interesting ways by political rhetoric in ways that might concern us today. And this symposium had the salutary effect of, as Dean, of getting me to do new research this week. It's a nice feeling. But I found a really interesting new study in the Journal of Law and Economics published last year, which is a top peer-reviewed journal, by two scholars, Carlos Verdejo and Daniel Chen, which it's a pretty simple study design. They look back about 80 years of federal circuit court decisions, a universe of 20,000 cases, and their variable of interest is it a divided panel or not? How often are dissents happening? And then they throw in one wrinkle that I'll describe. And the baseline dissent rate has held pretty constant over the past 80 years at about 6 or 7 or 8% of federal circuit court panels are divided. And that correlates with what judges, the vast majority are unanimous. So then they divided every 4-year period up into 16 quartiles, and then they just isolated the quartile leading up to the November presidential election. And in those quarters, the same judges, life tenure, they controlled for case mix, the dissent rate doubled from about 6 or 7% to about 12 to 14%. Now, what's the theory there? These are not elected judges. They're showing that they're unanimous most of the time, so they're driven by legal factors, collegiality reality factors, but yet evidence of, and they, evidence of dissent and disagreement, which did correlate along party of the appointing president lines, doubles leading up to the election. And the theory, not fully explored in the paper, is that heightened political discourse rhetoric, fractious rhetoric, is going to make salient even to completely insulated judges. And this goes to the theme that judges are human beings. All of us, I think, deans are human beings. We have,
No.
we have unconscious biases. We have in the way we relate to individual people, in the way we relate maybe to our jobs. And so, it's important that we acknowledge that sometimes those surface. And again, I haven't, I don't hold this study up as necessarily the gold standard. It's in a top peer-reviewed journal. But what it suggests, by the way, the other thing they found is going all the way back to World War II, Korean War, Vietnam War, during periods of active, kind of universally agreed upon wartime, where, I'm not talking about conflicts that go on partisan lines, but where the country agrees that it's on war, dissent rates drop to about 3%, which again suggests that there are factors, institutional factors, and judges being human beings are willing to slightly modify their willingness to disagree on the law based on other factors. Now, what worries me about this is that by these authors' methodology, we're still several quarters away from a highly polarized political discourse, right? So it worries me that maybe the current state of our public civic discourse is so heightened and so fractious that we're kind of always running in leading up to an election mode. And if that's true, what looks like a fairly trivial little blip from 6 to 12% occasionally might worry us a bit about the courts.
I think that just underscores the obligation of the Supreme Court, which, is our great teacher in this frame, to try to dial it back and model for, not only for the public, but more directly for judges on the other courts, how to behave with civility, and how to find some ground on which they can agree, even if it's a pretty narrow ground. And Paul Clement talked about what he found remarkable in that bankruptcy case, that in that moment of transition, the dissenters could have exerted control by saying, we're not ready yet, and waited for Justice Alito to come and sit in Justice O'Connor's seat. They didn't do that. During the time when the court was down to 8 people after Justice Scalia died, that was a term of narrow, deferring things. And, the court that was sort of a crisis time institutionally. And the court might well step back and think, this is a crisis time institutionally. And we've got to watch ourselves. We've got to behave ourselves.
We'd love some questions or reactions. Dan?
So it dawns on me that abortion is one of these issues that lives in the lives of almost everybody because so many people are involved in reproduction. All right, reproduction and the choice of whether to do it. So abortion is a truly a near universal household issue. And as a political issue, a president can only deliver on abortion these days by delivering the court. So I guess my question is, so much of what we've been talking about today, and Linda, you gave 2 examples right there, is really work being done by the abortion issue? And how much of legitimacy in all of this is really a story about abortion?
Well, I think, a fair amount of it, but don't forget, church and state is a huge issue that's driving politics surrounding the courts. And I think the First Amendment is too, the sort of capture of the First Amendment by the corporations, the turn of the First Amendment toward a tool of deregulation. So I wouldn't sit here and say it's all abortion. I think that's certainly, higher on the surface, but there's a lot going on in our judicial political discourse.
I agree with that. I think that, we could do the thought experiment if there was some constitutional amendment one way or the other that, quote, purported to resolve the issue. Would we think that in political campaigns, kind of the supreme battles over the courts would drop out? I don't think that. I think there's enough other hot button issues that come up other than abortion.
Hello. I do have a question. I've had it written down, so make sure I get it right. So what do you make of the Supreme Court's decision to, quote unquote, overrule Korematsu in the context of the Muslim ban case?
I think it was a very long time in coming.
Okay, but it was, to me, I'm curious.
I can't hear you.
Was it curious to you that they did that in the context of the Muslim ban case, or did you think that was just an
opportunity? It came up in a very curious way as kind of a throwaway line in the Muslim travel ban case. I found that, kind of baffling, but, better late than never, right?
Here's a chance.
I have a question. In the context of the elitism that we were talking about earlier today, how do you explain to the general public things like Masterpiece Cake Shop and the subtleties of the issue, the way that issues were defined in a case like that, and take things out of this polarization, this political polarization that we're in when you're speaking to the general public about big decisions that are decided narrowly or broadly?
How do you explain Masterpiece Cake Shop?
Something like Masterpiece. How do you explain the concept of narrowly defining an issue to the general public in a way that takes the black and white tendencies of the public into account and explain the complexities of the judicial system? All the things that we've been talking about today, it seems to me, the general public may not be able to really embrace because we are in such a polarized time, and because we also don't have the ability to extend the discourse long enough to be able to explain the complexities of what we do. So what advice would you give us when we're talking to the general public about what judges do in terms of bringing it to the level that people can understand?
Yeah, well, I mean, I guess I have enough respect for the public that I think if they got the details, I mean, don't be afraid to lay on a little bit of homework on people. When I left the beat after many years, I got some mail from readers, people I didn't know, and the most heartwarming one I got was just simply one line. It said, "Thank you for never condescending to us." So I do believe people can understand, and when the court built up its website so that all the briefs are posted, the opinions are posted within seconds, the transcripts and everything. And I was still there on the daily beat, and I had a bit of a crisis, internal crisis. I thought, okay, what's my role? Anybody that really cares can just, with a few keystrokes, they can get it all themselves what they need me for. And then I realized that it's to provide context. Why is this case here? Where did it come from? Where's it going now? Where's the issue going now? And I think people are hungry for that kind of context that they can't get just by, reading the raw material. And those of us who are in a position, whether it's lawyers or judges for that matter, to interact with the public really, have an obligation to do the heavy lifting and lay all that out there.
Mm-hmm. I had the experience last spring. Eleanor mentioned I'm still teaching, and it's a neat program we have so I taught a class of constitutional law for non-lawyers. Is it the general public? It's mostly Penn affiliates, nurses, doctors, some undergrad students. But I actually taught Masterpiece Cake Shop, and I think they, just as well as law students, understand the nuance of a kind of context-specific procedural decision. Just like when I teach law students, I don't know that I help them to understand Marbury versus Madison, but that with all the writs and but that's hard even with law students. But I think I think the public, I think it's actually something, it's an initiative of this law school and many law schools, for a century or so, we've assumed that legal knowledge is kind of cabined within law schools in a way we don't assume economic or historic history or medical, and so we law schools can do much better at educating non-lawyers, and right now we've got about 300 non-lawyers taking classes this semester at Penn, and we're trying to expand that program.
Well, I think one of the best books that's come out about law teaching in recent years is a book by Paul Kahn of Yale Law School. It's a little book called Making the Case. And what he does is he says what's wrong with legal education is the case method. You just get snippets in the case book of what the case book editors thought, was the main takeaway from the case. And it doesn't teach law students how to interact with the entire decision and find the holding and find the rationale for the holding and so on, and read the full decision as a narrative. It's telling a story. The majority is telling one story. The dissent may be telling quite a different story, but there's storytelling going on there. And I just think that's a great insight, because law-trained people are, I think, overtrained to just extract the bottom line without the explanation that certainly the general public needs to understand what's happening.
Just one other thing, and then I see my colleague, in my current role, I talk to a lot of law firm hiring partners, and kind of working, and I say, what are we doing well? What can we do better? And we're doing much of the legal training is going well, but I heard it from a couple of top people. So you're not doing well enough at teaching your smartest students to talk to non-lawyers. Cut through the jargon, get to the, and it's inflected some of the ways that Eleanor Barrett and others we think about training lawyers here, that we want to, of course, give the doctrine, but then we need to, that notion of all of us in our profession translating in clear, and this would have, of course, been true of the framers, thought that the Constitution and our legal system was for every citizen to understand and discuss, not just some cloistered profession. Yes?
Linda, you're an extraordinary journalist. Not many journalists have your capacity both to understand Supreme Court decisions and to explain them. In recent work with a co-author, we found that the Supreme Court has been uniquely successful in retrenching the enforcement of private rights of action in federal statutes. And they've done it rather than by going after the statutes themselves and the underlying substantive rights. They've gone about doing this through standing, attorneys' fees, and the like. One of our hypotheses as to why they were uniquely successful, whereas Congress wasn't and the rulemakers weren't, and had to do with the fact that these decisions fly under the radar screen. And we got challenged. People said, well, what about Walmart? Or what about Lilly Ledbetter? So we did an empirical study of coverage of private enforcement issues and substantive issues in the Times, in the Washington Post, and in the Wall Street Journal. And as we suspected, the private enforcement issues get vastly less coverage. So my question to you is, what should we expect of journalists in general, of their ability to accurately convey what's going on?
Well, it's a complicated question, because what you need isn't simply, journalists on the ground, journalists in the, at the courts. You need editors and news directors who are committed to this enterprise. So occasionally I still get calls from Federal Court of Appeals judges who say, we want your advice. Our circuit is not being well covered. The press doesn't pay attention to us. We think in a democracy, our court ought to be covered. And do you think we should invite some reporters in and have, kind of FaceTime with them? And I say, before you invite the reporters, invite the editors, invite the TV, news director. They're the ones who have to be persuaded that they should do what, for instance, my editors did when I said to them, okay, for the next 3 days, the court's not on the bench, and you're not going to hear from me, because I'm sitting up in the press room reading cert petitions and reading briefs. And, you know, I'm telling you, that's a productive use of my time. I was one of the few reporters at the court who got away with that, because everybody else, if the court wasn't sitting, oh, there's something down at the Justice Department, you ought to, you know, we want you to go to cover that or something. So it's really an institutional problem. It's not the individual journalist.
And if I may follow up with that, what are the implications of, I mean, I understand there's been a wonderful turnaround lately with print media, but what are the implications of having more and more information on the internet and not in print media? Because I would imagine it's going to be even harder to get the devotion of the sorts of resources that you're talking about from internet entities.
Well, there's pluses and minuses to that. I mean, the minus is the you know, incredible appetite of all the websites. So people don't have time to think, and they have to post, you know, the breaking news immediately without processing it. And I would have been majorly unhappy to the extent I think I don't think I would have done it, to have to, you know, file, the court hands down an opinion at 10 o'clock and people have to file something by, you know, 10:30, which means you have to write in advance and top it with like who won and who lost. That's no way to, you know. On the other hand, the web has the fantastic ability of not being space constrained. So, you know, put up the whole opinion. I used to have to do my own excerpting of opinions and you know, or put up the transcript. So people who, you know, want to know more, you could go to different levels. So I don't knock the internet. And I guess part of your question was, well, what about the financial resources that support this? And I don't quite know the answer to how all these media outlets are doing. I think the Trump presidency has been a huge boon to the failing New York Times. Because there's like a million new digital subscriptions all over the world. People all over the world excuse me, are desperate to understand what's happening in the United States. And the easiest way they can do it is to subscribe to the New York Times. So
So thank you. Well, Linda, thank you. Thank you all. We've reached the end of our time.